The government is set to begin terminating contracts with hotels housing migrants across the United Kingdom. The plan should see about 50 hotels out of 400 having their contracts ended. This regime currently costs you about £3 billion per annum as 175,000 migrants await their asylum applications to be processed. The policy originates from the Asylum Act of 1999, another legacy of the Blair years. It requires the government to house asylum seekers. But it's come at a great financial cost and a social cost as well. Many communities are affected by the policy, with a number of small towns and villages expressing concern over the plans to bring hundreds of young men seeking asylum to their communities. But all this just goes to show that the Rwanda plan must work if we're to solve our migration problems, particularly our illegal migration problem. And making the Rwanda plan work means leaving the European Court of Human Rights or facing years of delay. And this isn't a problem unique to the United Kingdom. France is set to implement its toughest crackdown on foreign criminals in 30 years. Its Interior Minister, that's the equivalent of Home Secretary, announced plans to expel foreigners deemed to be dangerous without waiting for the ECHR to hear their appeals. In other words, it is doing something that the ECHR will deem to be improper. The ECHR court, could impose a fine on the French, but they will still refuse re-entry to the criminals. And this is part of broader plans from the French government to deport rejected asylum seekers. And it ties in with some of the gripes we have about the ECHR, which isn't, as some would have it, just an extension of Brexit. It's because there are other problems with the ECHR too. And the main difficulty for us and other countries within Europe arises from the court's method of judicial interpretation known as the living instrument doctrine, which allows the court to expand beyond what it was agreed that it should do when it was set up. It permits the court to invent rights that weren't in the original convention but are in the, quote, spirit of the convention. But there's no democratic mandate for this. There's no authority for this. It's decided by the judges. They're the ones who decide which rights are in the spirit of the convention, not you. And these judges are in some cases politically nominated, not ours, but from other countries. And as a very distinguished former Supreme Court judge, Lord Sumption, has pointed out, there is nothing in the ECHR that we cannot enact by ordinary domestic legislation. We can have whatever rights we want if there is sufficient democratic mandate for them. And that's the point. Our rights come from our democracy, from you, the people, through Parliament, not from the ECHR. So it's time to leave the convention so that we can pursue our own unabated migration policy.